Good morning, everyone. We will begin with the matter of Ike with regards to the application for a Section 590AA argument. Could the defence please address the court?
Your Honour, if it pleases the court, my name is Shumilin, S-H-U-M-I-L-I-N, initials D. It is my appearance here today with the purpose of acting on behalf of the defendant, Marshall Ike. Your Honour, Mr. Ike is being charged with 84 counts of breaking and entering and 1 count of stealing. It is the belief of this lawyer that there exists evidential argument to exclude current evidence with regards to these charges, thus the point of seeing today's matter as a Section 590AA argument. For the record, Mr. Ike is currently in custody and unable to post bail, and I'm acting on behalf of the defendant upon assignment from Legal Aid Queensland. Before continuing, Your Honour, I would like to tender my submissions to the court for future and concurrent reference in pursuit of my case. Thank you very much. Now, Your Honour, the defence submits an application for the exclusion of the evidence put forth by the prosecution with regards to these 85 charges against Mr. Ike. Now, I make the submission with respect to the argument that the policing officers responsible for the collation of the evidence in this matter did not comply by the rules outlined in the Police Powers and Responsibilities Act, Queensland. Now, Your Honour, it is my understanding that you are in fact familiar with the facts of this case.
Yes, Mr. Shumilin, you can continue with your arguments.
Thank you, Your Honour. With this in mind and with reference to these facts, let me tell you a little bit about Mr. Ike, Marshall Ike, if you will. Now, Marshall is a 14-year-old Torres Strait Islander boy from Townsville. Both Marshall's young age and his cultural background must be taken into account during questioning and evidential procedures, as per Section 421 and 420 of the Police Powers and Responsibilities Act, respectively. With this in mind, I would like to draw attention to 3 matters in which the evidence brought by the prosecution has been improper. Firstly, Mr. Ike's age. Section 6, subsection 2 of the Youth Justice Act, Queensland, designates a person who is under 17 years of age a child. Based on this, Mr. Ike is a child according to the law, and thus must be treated with the various principles when questioned and when he was apprehended. Section 421, subsection 2 of the Police Powers and Responsibilities Act designates that before questioning a child, a police officer must allow the child to contact a support person, if possible. Now, while in the facts, a support person was eventually contacted, albeit incorrectly, via no conferral upon Mr. Ike during this whole process. This person was still not apparent during initial questioning, during which the police drove Mr. Ike around. The moment police moved to arrest Mr. Ike, they should have contacted such a support person before beginning any questioning of any kind. This must occur if the police officer reasonably suspects that the person they are beginning to interview is a child. That's per section 421, subsection 1, A and B. Now, I make the argument with respect, Your Honour, that Mr. Ike is a 14-year-old boy who could be heavily assumed, or at least reasonably assumed by the law, to be of an age applicable to these rules. Secondly, Your Honour, I draw inference to Mr. Ike's cultural background. Again, with reference to the Police Powers and Responsibilities Act, this time section 420, if the questioning officers in this case had any suspicion that Mr. Ike was of an Indigenous or Torres Strait Islander background, they must immediately notify legal aid and inform the interviewee of this procedure. This did not happen until my organisation was notified after all initial questioning procedures. Now, the prosecution may argue that as per subsection 3, this does not apply if the interviewee had a level of education or understanding that wouldn't put them at any special disadvantage. Now, Your Honour, again, Mr. Ike is a 14-year-old boy, a person who, regardless of his cultural background, would assumably still not have the level of understanding and knowledge required to be fairly treated by this scenario. Now, thirdly, Your Honour, I draw inference to the way Mr. Ike was questioned during this improper questioning procedure. For instance, Mr. Ike was not cautioned as per Section 22 of Schedule 9 of the Police Powers and Responsibilities Regulation, Queensland, towards the questioning process in which he was subject to during this lengthy drive. He was not cautioned as per Section 431 of the Police Powers and Responsibilities Act of his rights to silence and possibility of self-convicting evidence. This, however, fails in comparison to the way that the police officers led questions to the 14-year-old boy, and this clearly shows signs of gratuitous concurrence. Your Honour, I would draw your attention to my submission in which the unreported case of the Crown and Kennedy clearly mimics the facts of this case and outlines the dangers of misrepresentation and gratuitous concurrence. Coupled with the Indigenous and Torres Strait Islander background of Mr. Ike, with reference to the Equal Treatment Bench Book of the Supreme Court, a culture in which the relationship establishment can misrepresent intentions and project unobjective accuracy, this case clearly shows signs of potential gratuitous concurrence. Police officers in a position of power, whom clearly did not abide by the rules set in place to protect people like Mr. Ike. It may be difficult to feel empathetic to Mr. Ike, but I ask you to try. How did he feel in this situation? Your Honour, it is the defence's argument that the matter in which the evidence in this case was procured stands to represent a threat to the fairness of the court and the dignity of the administration of the justice system. There is blatant disregard for the law here, an act which undermines the process put in place to protect those most vulnerable in our society. In the High Court case of Bunning and Cross, this sort of behaviour is one that the courts should not and previously did not allow. With regards to these arguments, I ask the court to exclude this evidence if it is satisfied that it would be unfair to the person charged with to admit this evidence, as per section 130 of the Queensland Evidence Act. Mr. Ike has been wronged by the legal powers designed to protect him. A young man who stands on the brink of unfair handling at substantial ramifications. All Mr. Ike asks for is fair and just treatment, and that is the backbone of the legal right in our society. Let us not allow Mr. Ike to fall through this embrace. This concludes the defence's verbal submissions. Thank you, Your Honour.